HighBridge, a division of Recorded Books, presents The Individualization of War: Rights, Liability, and Accountability in Contemporary Armed Conflict by Dapo, Akande, Jennifer Welsh, and David Roden. Read by Rick Adamson. Introduction. Understanding Individualization. Jennifer Welsh, Dapo Akande, and David Roden. The rights and responsibilities of the individual are at the center of today's armed conflicts in a way that they have never been before. This process of individualization, which challenges the primacy of the sovereign state, has two main drivers. The first are powerful normative developments related to human rights, which have elevated human-centric versus state-centric conceptions of security and which have spawned new kinds of wars and peacekeeping missions and a new class of international crimes. The second are dramatic technological and strategic developments that can both empower individuals as military actors and enable either the targeting or protection of particular individuals. The individualization of war forces us to confront the status of individuals in at least three different capacities. One, as subject to violence but deserving of protection. Two, as liable to harm because of their responsibility for attacks on others. And three, as agents who can be held accountable for the perpetration of crimes committed in the course of conflict. These three domains served as the organizing framework for a large-scale interdisciplinary research project funded by the European Research Council, which we co-directed, and for a gathering of leading thinkers from the fields of international relations, political science, and moral philosophy, who we encouraged to engage with the phenomenon of individualization. Their reflections and arguments further our understanding of not only how individualization is manifest in contemporary armed conflict, in theory and in practice, but also what challenges it poses for today's scholars and practitioners. Our collective research also integrates the currently segregated scholarship on individualization in moral philosophy, international law, and international relations, recognizing that, with some notable exceptions, analysis of individualization has proceeded largely in separate streams without recognition of the important links between law, morality, and politics that constitute the day-to-day reality for policy actors. Our analysis of individualization starts from the assumption that while the human rights norms underpinning many aspects of individualization may be normatively desirable in themselves and enjoy relatively strong support, efforts to operationalize norms related to individual protection, liability to harm, and accountability are placing enormous strain on the actors and institutions most actively engaged in contemporary armed conflict, the governments and armed forces of states, international security organizations, and humanitarian agencies. More specifically, individualization is giving rise to a set of ethical, legal, and political dilemmas that are confounding contemporary policymakers, and in some cases weakening the legitimacy of national, international, and non-governmental institutions. For example, in the realm of protection, the UN Security Council remains caught between its state-centric constitution, which has traditionally demanded the even-handed treatment of parties to a conflict, and the recognition of its responsibility to protect individuals, illustrated in the contrast between the relative speed with which the Council was able to act in Libya in 2011 compared with its later failure to reach a consensus on how to respond to documented crimes against humanity in Syria. In the UN's most extensive peacekeeping mission in history, in the Democratic Republic of Congo, peacekeepers have faced agonizing strategic and operational dilemmas over how to fulfill their civilian protection mandate, which requires addressing atrocities perpetrated by either state or non-state actors, while at the same time avoiding criticism that might alienate the government of former President Kabila, whose consent has been critical to their continued presence and which was eventually withdrawn. Turning to the domain of harm, we learn that unmanned aerial vehicles, UAVs or drones, have seemingly offered state leaders and national militaries opportunities to target lethal force more precisely against a specific individual who poses a grave threat, thereby minimizing both collateral damage and the loss of their own personnel. Indeed, some moral philosophers have argued that there is an imperative to employ these more precise weapons. On the other hand, the use of lethal force by the executive branch of governments without judicial or legislative oversight has called into question fundamental protections of a liberal democratic society and arguably weakens some of the restraints embedded in just war principles such as last resort. Moreover, other actors have also increasingly come to use these precision tools of war, with uncertain and destabilizing effects on both the nature of conflict and the rules that seek to govern it. In the case of accountability, diplomatic actors continue to face a dilemma between pursuing criminal action against individual perpetrators, as they did in Libya in 2011, which can close off options for negotiation that might bring a more rapid end to conflict and civilian suffering, or privileging conflict resolution strategies that deny justice to some victims of international crimes and contradict rhetorical commitments about ending impunity. Contemporary legal practices associated with accountability also place humanitarian agencies in a deeply uncomfortable position, since they are closer to the crimes of war than most other institutions and could potentially provide evidence in criminal proceedings. To give such evidence, however, could make their personnel the targets of violence, or, as in the case of the International Criminal Court's investigations in Darfur in 2005-6, persona non grata, thereby rendering it impossible for them to continue to protect civilians on the ground. These seemingly discrete dilemmas are all underpinned by a tension between the privileged moral and legal claims of individuals and the technological changes that often enable them, and the more traditional ones of sovereign states. Methodologically, the project on which this volume draws entertains alternatives to the traditionally dominant state-centric paradigm for the analysis and regulation of armed conflict in the disciplines of international relations, international law, and moral philosophy. At the same time, we recognize that a great deal of existing literature on individualization is inherently progressivist. In international relations, for example, prominent scholars have posited that the commitment to individual human rights is now firmly embedded in norms and law, and that the most pressing task ahead is to design a better strategy and stronger institutions to ensure compliance with that commitment. In moral philosophy, scholars mounting revisionist challenges to modern just war theory argue that while the current law of armed conflict is often incompatible with an ethics of war based on individual human rights, this disjuncture between law and morality is not sustainable, even if there are strong prudential reasons for maintaining it. And in international law, some analysts argue that individual human rights and accountability have transformed states' conceptions of their rights and responsibilities and the relationship between the state and the individual. In this volume, we acknowledge that both in practice and in scholarship, individualization is not always held to be an unmitigated good. Analysts have noted the potential for individualization to create problematic forms of asymmetry, in which only the powerful, most notably Western states, have the advanced means to individualize protection, liability, and accountability, and in which the reciprocal obligations of IHL are weakened. Individualization has also been accompanied by double standards and hypocrisy. Some of the loudest calls for respect for individual human rights come from those whose drone strikes lead to excessive civilian casualties. At a more fundamental level, some have expressed deep unease with the way that individualization can work to transform war itself, either by depoliticizing conflict and delegitimizing particular actors, or by broadening the geographical reach of the battlefield. Relatedly, critical theorists have taken issue with the methodological individualism that underpins recent ethical theorizing about armed conflict, arguing that it not only oversimplifies the nature of war by depicting it as the aggregate of individual actions or decisions, but also constructs a problematic and partial account of moral agency that reproduces existing privilege and reflects a parochial historical imagination. Given our core interest in analyzing how individualization is manifest in the study and practice of armed conflict, and the tensions to which it gives rise, we do not explicitly engage with or in critical theorizing. Nonetheless, some of our contributing authors openly question the argument that individuals or individualist values should dominate the ethics, law, or politics of armed conflict, expanding on earlier observations about how the imperative to protect civilians or hold individual leaders accountable can conflict with other powerful norms such as non-intervention, impartiality, or the peaceful resolution of disputes. We also elaborate on how the implications of individualization have become evident within national governments, as well as within international and non-governmental organizations, as they seek to navigate a new ethical and legal terrain. Humanitarian agencies, for example, experience profound disagreements within their own organizations over whether and how to cooperate with Western governments pursuing protection and accountability. Concerns about individualization feature, too, in the evolution and contestation of the principle of the responsibility to protect, particularly in the discourse of practice of states that seek to emphasize the primary responsibility of national governments to protect their own populations and to downplay the remedial responsibilities of the international community. Finally, non-Western states often point to the uncomfortable reality that the operationalization of norms related to individualization is often directed solely at countries in the global South, manifest in the fact that humanitarian interventions have yet to occur in developed countries, with the exception of the former Yugoslavia, and that the criminal cases pursued by the International Criminal Court have related primarily to African countries. More broadly, scholars and policymakers have pointed to a series of trends that are undermining the human rights advances that help to fuel key aspects of individualization. The international order has been experiencing a profound structural shift, which gives increased power to states such as Xi Jinping's China and Vladimir Putin's Russia, both of which have openly challenged human rights and accountability norms and have promoted more Westphalian conceptions of sovereignty. Russia and China have exerted their own sovereignty by crushing dissent and secessionist stirrings at home, and attempting to extend their power and jurisdiction over other self-determining communities. But they have also supported other regimes, including in Syria and the Philippines, to reassert sovereign control and limit external interference. Elsewhere, the national populist revolt in Western democracies has targeted human rights institutions as well as the global economic system in which they are embedded. For his part, former U.S. President Trump did little to stem the tide against globalization and liberal internationalism, preferring instead the rhetoric of America First and rejecting what he has disparagingly referred to as the ideology of globalism. All of these forces, it has been suggested, are challenging post-Westphalian visions of a shared global order and giving way to an era of resurgent sovereignty. Within this context, there is greater momentum behind the argument that individuals should be subsumed morally and politically into the state in times of war, rather than made a specific focus of norms or law related to armed conflict. Even long-standing principles of international humanitarian law are now routinely under attack, including by liberal democracies, whether through their own actions or those of their proxy fighters. Not only are legal rules being violated, but actors are increasingly questioning the standing of and rationale for such rules. Indeed, the legal advisor of the International Committee of the Red Cross, ICRC, has warned against creating a vicious cycle in which not respecting the laws of war becomes the new normal as states and armed groups seek to justify their violations as inevitable and realistic behavior in armed conflict. These critiques and forms of pushback therefore cast doubt on linear teleological models of normative change, and call for an approach that both accepts and analyzes the potential for ongoing contestation of individualization and the norm conflict that it can entail. In other words, we do not assume that efforts to operationalize individual rights, liability, or accountability in the context of war necessarily fix the meaning of norms associated with individualization, or ends the debate about either their desirability or applicability in particular cases. An appreciation of the reality of contestation not only enriches our study of the dilemmas associated with individualization, but also requires us to look beyond technical solutions, such as better coordination or more resources, for ways to address them. They also suggest that the trajectory of individualization remains unclear, a theme we return to later. In the rest of this introduction, we further elucidate our concept of individualization and how it challenges more traditional collective entities and values, identify some of the tensions to which it gives rise and how they are being resolved, and posit the different ways in which individualization is currently being contested. We conclude by providing an overview of the subsequent chapters in which international lawyers, philosophers, and political scientists further engage with the potential and limitations of the individualization of war. 1. Conceptualizing individualization. In its most general form, individualization is a process in which individuals rather than collectives increase in salience, both empirically and normatively. To arrive at a more specific definition for use in the context of armed conflict, there are two distinctions that are central to analysis and normative assessment. The first is the distinction between an agent, actor, and a subject, acted upon. A. Individualization is the process in which the agency of individuals, rather than of collective actors, increases in importance in the causes, conduct, and consequences of war. B. Individualization is the process in which the effects on individual rather than collective subjects increase in importance in the causes, conduct, and consequences of war. The second is the distinction between the role that individuals play in explanations and normative assessments of the phenomenon of war. C. Individualization is the process in which individual agents and subjects play an increasingly important role in our descriptions and explanations of the causes, conduct, and consequences of war. D. Individualization is the process in which individual agents and subjects play an increasingly important role in our normative assessment of the causes, conduct, and consequences of war, where normative assessment entails assessing reasons for action, including ethical, legal, and strategic reasons for action. 1.1. The domains of individualization: protection, harm, and accountability. By integrating these two aspects, we define individualization as a process in which individuals, both as agents and as subjects, increase in importance compared to collective entities for the purposes of explaining and normatively assessing the causes, conduct, and consequences of war. We further suggest that individualization in the context of war forces us to confront the status of individuals in at least three different domains. 1. As subject to violence but deserving of protection, given their individual right to life. 2. As liable to harm because of their responsibility for attacks on or threats posed to others. And 3. As agents who can be held accountable for the perpetration of crimes committed in the course of conflict. The process of individualization can thus be conceived as affecting the ways in which individuals are protected in war, and the bases under which and ways in which they can be legitimately harmed or held to account for their actions. The first major aspect of individualization is the move to make the individual and his or her rights one of the central reasons or causes for engaging in armed conflict, what is referred to in just war literature as jus ad bellum. Whereas conflicts in previous centuries were primarily about the gain of territory or resources, defense of the state against attack, or, in exceptional cases, the rescue of minority groups in neighboring states, many contemporary conflicts have as one of their central and explicit purposes the protection of individuals' security. The NATO-led action in Libya in 2011 was one highly visible manifestation of this trend. But the practice stretches back to the significant shifts in UN Security Council practice in the early decades of the post-Cold War period, which enabled the United Nations to broaden its definition of what constitutes a threat to international peace and security, and to the endorsement by UN member states in 2005 of the principle of the responsibility to protect. In addition to justifying the use of force, the protection of civilians has transformed the practice of peacekeeping. Beginning with the conflict in Sierra Leone in 1999, the UN Security Council routinely began to include civilian protection in peacekeeping mandates, calling on member states' contingents to respond to and prevent extreme violations of human rights. Hence, while during the Cold War era peacekeepers practiced a more passive kind of impartiality, in which they were beholden to the wishes of the parties to a conflict, contemporary peacekeepers have been expected and mandated to be robust and assertive by penalizing infractions against the peace process or broader international norms and principles. Today's blue helmets are now being tasked with roles akin to those of police officers and expected to search for and then side with the victims of violence. The second key dimension of individualization concerns the ways in which individuals can legitimately be subjected to harm, such as lethal force or detention, in the context of armed conflict. Analysis here has focused particularly on the move to both establish and act upon individual liability rather than conflict status in the conduct of armed conflict, what is commonly referred to as the domain of jus in bello rules. Modern just war theory and the contemporary law of armed conflict assert that principles of liability and immunity derive from a person's status or membership in a particular group, combatants or non-combatants. But a powerful stream within moral philosophy, just war revisionism, has challenged this status-based approach to the ethics of war using the framework of individual human rights. If all persons have rights, and if important rights such as the right to life can only be lost or forfeited on the basis of some responsible action of the right bearer, him or herself, then it seems to follow that liability can only be established by examining the particular circumstances of individual actors within a conflict. There are three important implications of this logic. First, human rights premises raise the question of which combatants are liable to be targeted in armed conflict, thereby challenging the traditional just war position of the moral equality of soldiers. According to the revisionists, rights-bearing individuals can only become liable to lethal violence when they are responsible for inflicting grave, unjust harm on others. This conclusion suggests that just combatants, those fighting a morally or legally justified war, are not liable to be intentionally targeted. Individual soldiers are only liable if they are fighting in a war that is illegal or unjust. A position in favor of asymmetrical rights and responsibilities also has dramatic implications for how the practice of military establishments would need to be configured, as exemplified by the rules of engagement of UK forces in Afghanistan, which permitted engaging the enemy only if it posed an imminent threat to others. In addition, individualization has implications for the status of civilians in war, who have long enjoyed protected status under the legal and moral principle of distinction. But some philosophers have begun to argue that certain non-combatants, such as the leaders of so-called rogue regimes or terrorist organizations, can be liable to intentional attack if they are responsible for sufficiently grave, unjust threats against others. At the same time, technological advances, as described previously, have enabled states to operationalize individual liability, particularly as part of counterterrorism operations through the use of remotely controlled UAVs. The final implication of revisionism relates to how, if at all, the tenets of individual liability to attack can be compatible with current or modestly amended interpretations of international humanitarian law. While some critics maintain that the circumstances of war are so unique and so devastating that war must be regulated by its own form of morality and law, human rights principles are already intersecting with, and in some cases challenging, the nature and scope of the law of armed conflict. Legal analysis of the increasing co-application of international human rights law, IHRL, and international humanitarian law, IHL, is based not only on reference to and application of IHRL to conflict situations by courts and treaty bodies, but also on more normative arguments that warring parties must be accountable for how they treat rights-bearing individuals in the context of armed conflict, and that the more traditional status-based determination of who can be killed or detained violates core rights. Attempts to give effect to the norms and laws regulating armed conflict have traditionally focused on the imposition of obligations on states and state-like actors. Over the course of the last century, however, specific obligations have been imposed directly on individuals as either leaders or soldiers, breaches of which give rise to accountability for criminal acts undertaken during the course of war. This third and final domain of individualization culminated in the 1998 Rome Statute, creating the International Criminal Court, ICC. There are two main challenges that this aspect of individualization poses for existing mechanisms for preventing, managing, and resolving armed conflicts, and for existing principles of international law. The first set of challenges arises from the ICC's status as a permanent court, with universal jurisdiction that can activate investigations of individuals independent of the consent of states. Consequently, recent decades have witnessed the increased engagement of the court in ongoing armed conflicts, as well as the threat of prosecution as a tool of coercive diplomacy in situations where atrocity crimes have been committed or are imminent. Although these powers of the ICC enhance the prospects for accountability, they have had a number of further, in some cases unintended, consequences, and raise important theoretical and practical questions about the relationship between peace and justice. Furthermore, there are significant issues with using criminal justice instrumentally as part of international diplomacy including the possibility that these strategies potentially destabilize existing mechanisms for resolving conflicts peacefully and challenge the United Nations' traditional approach to treating conflict parties even-handedly, and the increased role for domestic as opposed to international.
Sample complete. Ready to continue?